702.
World of Work.
World of Work indeed. My guest is Dumisani Ndiweni, partner at law firm Webber Wentzel, and we want to explore this matter of harassment in the workplace, particularly sexual harassment. As I said, it continues to be one of the most pressing challenges facing organizations across South Africa. And while the legal framework and other statutes and company policies provide a structure for addressing complaints, the experience is something different on the ground, especially if you're a victim. You want to see things done. And at times victims feel that their voices are overshadowed by technical defenses, aggressive tactics, and a process that leaves complainants feeling re-traumatized rather than protected. At the same time, employees face serious legal, financial, and reputational risks when harassment is mishandled. So there is that responsibility on the side of employers to make sure that it's handled properly. There could also be CCMA awards that are in favor of the victims. So employers need to be careful as well. So Dumisani Ndiweni joins us right now. Dumisani, thanks for your time. Dumisani, so I should say apologies. Dumisani, thanks for your time. Welcome to 702. It's great having you with us. Good morning.
Good morning, Thabo. Thank you. Thank you for having me, and greetings to your listeners.
Thanks very much. How widespread is this issue, particularly sexual harassment in the South African workspace, Dumisani? And how are organizations currently handling this sensitive hot potato?
Look, Thabo, sexual harassment in the workplace is something that is challenging all organizations across all industries. The reality is it's more common than people actually think. We have laws and policies that provide a framework for these sort of handling these complaints. The way these cases are managed in practice often determines whether the employees truly protect their people and themselves. Many companies to date have policies on paper, but when it comes to actual implementation or dealing with the complaints, that's where we see the real challenges emerge. I mean, the good news on the one hand is that the awareness is growing and more employees are speaking up about it, and certain employers are actually taking steps to ensure they try and eradicate this form of harassment in accordance with the code of good practice when it comes to the prevention of such conduct.
And Dumisani, I often try to go a few steps back because I'm of the impression that we may not have a common understanding of one, harassment, and two, sexual harassment. Because whilst you engage with it at a very professional and legal phase of this issue, there could be an employee who interacts with it pragmatically but is not necessarily aware of the legalities around it. Plainly put, what is harassment and sexual harassment?
Look, Thabo, I mean, harassment and sexual harassment, I'll just group it together in this particular case, will be any unwanted conduct of a sexual nature that is offensive, intimidating, humiliating, degrading, and can create a hostile environment. That will be the broad strokes of harassment. But when you get into sexual harassment, it, in addition, can be split into physical and non-physical harassment. For instance, physical, we would both appreciate would be somebody just touching somebody inappropriately. Non-physical will be jokes and sexual innuendos that are suggestive in nature, of a sexual nature. So that's in like simply put, that's what harassment and sexual harassment would be. And
the gray line therein, and you mentioned unwanted, right? That could be a little bit murky, and I'm just wondering to what extent can the level of being arbitrary be taken into consideration herein, wherein I could have felt that what I said was not necessarily harassment and was in a way how we often relate to each other. But today you may have deduced offense therefrom, because we're no longer on good speaking terms.
Yes, Thabo, those complexities do arise, and we need to be cognizant of them. The reality of it is that, and legally, is that sexual harassment doesn't need to be a consistent occurrence of certain conduct. It can be that two individuals were in a relationship, are still in a relationship and work in the same space. However, on this particular day, one of the individuals felt that the comment which was projected towards them was unwanted. That could constitute sexual harassment, even though they are in a relationship. And for the accused employee then now to put a version and defend himself or herself, they would then in a hearing or in a platform have to articulate that this is how we ordinarily engage. I was not aware that it was unwanted at the time. And a chairperson would have to sit and make a determination on whether there's any plausibility to the defense which this employee is raising.
And I'm just wondering, as a fair HR personnel, a lot of people argue that that doesn't exist at all, fairness in HR. But let's assume that HR would be fair. And you are placed, between a rock and a hard place, even though it's your job. Thabo comes to complain. But also, how do you balance the interests of the employer and the employee in this instance? What is at merit here? What is at stake?
Yes. So, look, Thabo, I'd have to say to you, we should be optimistic and hope that in this scenario, because they are the custodians.
Yes.
Of our policy.
I'm being naughty. Let me remove that from the table. I'm just being naughty.
But it is. Look, Thabo, your question is not misplaced.
Sure.
Because as an employee who's a victim of sexual harassment, and I happen to raise the complaint, and I'm fully aware that the accused individual is friends with HR, for instance, because
yes.
we're all in a work, people engage and interact.
Yeah.
There is that feeling that could come about. But this is where it's crucial that employers, when handling sexual harassment cases, adopt a very high level of sensitivity. And that means that in disciplinary hearings relating to sexual harassment, it's always advised to really get an external, objective, seasoned chairperson who can sit and actually listen to the case objectively without any fear or bias. Whereas if you were to take misconduct, Thabo, such as absenteeism, for instance, right? And you've got a company with 500 employees and there's 10 senior managers. A senior manager which does not manage the employee who was late could easily chair that disciplinary hearing. There's not much controversy with that. The problem with sexual harassment is that because of the nuances and the sensitivities around the subject itself, it requires a skilled person who understands what the law is, what the latest case law is, and how to also ensure that the accused has an opportunity to defend themselves, but at the same time, not in a manner that undermines or reignites the trauma potentially that the victim has undergone already.
I want to be a little bit practical, Dumisani, and with that, let me urge our listeners also to participate and give us a call. Dumisani Ndiweni is partner at Webber Wentzel. Feel free to call in and ask him questions, share with us your experiences. I'd love to hear from you because it could be that we are removed from realities on the ground. It could be that we are not touching and striking a nerve as we ought to, and you've got an experience that is pertinent to this discussion. Don't withhold it. Don't go elsewhere. This is where you need to be. Just simply call us. Feel free to remain anonymous, and I'm happy to take your calls on 011-883-0702. Alternatively, it could be that you just want to deposit a voice note of about 30-40 seconds and leave it at that without us having to engage. Most welcome to do so. Or a text message even. Also, that's fine. Feel free to do so on 072-702-1702. I'd love to hear from you. And then, Dumisani, will come back just after the break, and then I'll ask you the question that I had intended for you.
No problem.
702.
World of Work.
World of Work on 702, 20 minutes after 11 o'clock. My guest, Dumisani Ndiweni, partner at Webber Wentzel, who is speaking about that sensitive hot potato harassment at a workplace, including sexual harassment. How do you deal with it as a boss and as a victim? Which channels should you explore, especially if you don't feel very safe around the individuals who are meant to be protecting you? I asked you to send your voice notes. You've done so, and your calls on 011-883-0702. But first, let's take this text message, Abel, that has been here for some time. Then we'll go to that voice note. Good morning, Thabo and your guest. I know someone whose boss frequently touches her inappropriately, despite her very clear protests. The employer apparently does this to other female staff members, knowing full well that no one can afford to lose their job. There's no HR person, and there's also a fear that taking the employer on may make future employment elsewhere difficult. The reality is the law doesn't always fully appreciate the day-to-day practical implications of such situations, nor does it make it very easy for victims to speak out. Coming from Kingsley in Germiston. Dumisani?
Yeah, Thabo, look, we don't agree on taking such difficult questions.
Yeah.
That's a difficult one. Very difficult. Look, that's the reality. Smaller businesses which don't have established HR functions,
yes,
or strong enough HR personnel to deal with these sort of things, it becomes very difficult. And I appreciate the text message you received, because it's difficult for them. And generally, from my analysis of this, what generally happens is that employees end up resigning and following the constructive dismissal route, which is, constructive dismissal is very difficult to prove in South Africa. But if there's sufficient evidence collated and collected by the individual, they could have a good chance to be successful at the CCMA with such a claim. But the reality of it is that the economic market doesn't have as many jobs available for individuals at the moment, and people are scared and are hesitant to take action against their employers, particularly in smaller organizations where there is no support. And the only thing I can really think of right now is that particular individuals should collect as much evidence as they can, so that when an opportunity arises where they can find somebody they can trust within the organization, they can report it with sufficient evidence to do so.
It becomes a little bit more complicated if it's the big boss right at the top, because it means that he's also boss of HR, and things can get a little bit murky. And I'm not just creating a hypothetical situation. I'm not going to mention where, but a place where I used to work some time ago, a big boss would come through and massage ladies on their shoulders as they were sitting on their desks. And you'd see others were feeling a little bit uncomfortable. I must be careful not to mention names so that I'm not sued. Others were feeling a little bit uncomfortable, including someone who was working in the HR herself. She'd be subjected to the very same. And I could just imagine that it becomes a very tricky situation if it's someone right at the top who's got access to all your files and who can make your lives a living misery at work.
You're correct, Thabo. Usually when it's and it goes back to the issue I said that if there was a seasoned HR, it would be easier to handle this. But when there is no HR like that, and when it is somebody that's so senior, there always seems to be this unclear route for employees to follow or employees to trust. Because you must appreciate that a sexual harassment victim, one, is traumatized, two, already feels vulnerable, and three, does not trust the system or the process itself already. And that's where a lot of them end up resigning under the guise of constructive dismissal. There's also been recent cases that have developed where employees resign and launch disputes and claims and basically sue the company under the concept of vicarious liability, where the company is held liable for failing to take appropriate action to eradicate harassment within the workplace. So that's the other route. But on a daily basis, when a person has no alternative job, it does really become difficult for them to just leave their job and follow up with such a case.
Certainly. Another text message here says, "Hi Thabo, when attending a CCMA training on behavior at the workplace, we were warned about hugging between us as colleagues. You can easily be charged with sexual harassment." Does it go as far as hugging?
Yes, I mean, Thabo, as I said to you, I mean, if I meet you for the first time and I hug you, and you just felt that the hug made you feel a little bit uncomfortable and it was unwanted,
yes,
it could go as far as that to an inquiry. However, it does not mean that every sort of form of unwanted behavior will automatically result in a dismissal.
I see.
It might result in an inquiry, and an appropriate sanction for that conduct will be allocated. It might be a warning, a verbal warning. It might be some training in terms of to caution you about the environment you work in, to appreciate that not all colleagues are open-minded. Not the correct word wouldn't be open-minded, but not all colleagues are receptive
yes.
to your conduct, and you need to be cognizant of that. So it varies depending on the depth of the misconduct.
Yeah, the open-minded thing was going to lead me to ask you what's going on there at Webber Wentzel that we don't know. But
Hey,
we'll leave it for another day. Great. Let's take a voice note on 072-702-1702.
Hi, Thabo. Please, can your guest clarify? In the workplace, people make jokes all the time. So when does it become harassment? Is it harassment from the very first time someone says something that you don't like? Or is it only harassment after you have informed that person that you're offended or you don't like what they have said? This is Tidi.
Thanks, Tidi. Dumisani?
Look, TD's query, harassment can be the very first time without you having articulated your displeasure of the conduct, because sometimes there's scenarios where you can't really articulate your displeasure or your uncomfortability. So the law caters, and there's a lot of case law which caters that a victim of sexual harassment doesn't really have to say, I don't like that. There's various other ways to see that a person doesn't want that conduct, the way she responds in terms of physically, or he responds physically. Or sometimes what would occur is that a person would not realize that they felt uncomfortable at the moment, but as soon as they walked away and got into their car, and they just break down into tears. At that moment, they did not have the opportunity to tell the person they are uncomfortable. So harassment can be at any stage, as long as the person feels uncomfortable and it was unwanted.
28 minutes after 11 o'clock, 072-702-1702. I'd love to hear what you have to say.
Hi, 702 family. My question is, if I as an employee form a relationship with another employee, what steps do I need to take to ensure that HR knows of this? And when the relationship ends, do I need to inform HR that the relationship has ended?
Dumisani?
Yeah, so Thabo, that one is, some employers have what you call a fraternization policy, right?
Yes.
Which sort of regulates internal relationships between colleagues. So employees need to check if that's there and probably follow whatever those requirements within those policies are. Some employers have adopted a sort of more free approach where anybody can date whoever they want. And it is prudent, I'd rather say, is to inform HR that we are in a relationship. It's not just for sexual harassment purposes. It's also just for situations of line management. It's generally not that you need to disclose if you are managing the person you're in a relationship with, for instance, because obviously that will affect how you handle certain situations at work. The funny thing, I'll say to you, is despite that, the Labour Court has actually said on several occasions that the workplace is not a lover's paradise or a love nest where people must go and use it as a dating pod or a dating pad. So obviously, it's always recommended to avoid relationships at work, but sometimes love finds you in the workplace, and it's prudent then to just notify HR of this. But even if you've notified HR and you are in a relationship, it goes back to my earlier point. You could be in a relationship with Cindy, and you and Cindy are in a relationship. Cindy can still raise a sexual harassment claim against you, even though you're in a relationship, and it's known with the business.
Very interesting. I will come back to that conversation with Dumisani Ndiweni, who is a partner at Webber Wentzel.